Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are going to be covering, well, we already covered this. It's closing arguments and then the verdict. But what we're going to do today... So what we're going to do is, because the feed, it was weird. It was like, it was live, but then remember, it was just kept spinning and spinning and spinning. And then ultimately, we did find the verdict, but it was on another channel, and we didn't actually hear the verdict. So it was kind of a, it just wasn't what I wanted to end this trial with. So what I wanted to do, and I spoke with Aaron about it, you know, because this channel is all about preserving the record and having our library. So if people go back, you know, a year from now, a month from now, 5 years from now, whatever the case may be, they'll be able to watch the entire trial. So because the verdict was kind of messed up, we wanted to do just a stream on just the closing arguments and then a verdict, and then we have a press conference. So we found a press conference with the family. So that's what we're going to do today. So hopefully, if you guys missed the closing arguments and the verdict on Friday, you'll watch with us. And if you watch them with us, it's just a chance to hang out and talk to friends. So then there's that as well. So with all that being said, I just wanted to welcome in everybody who is with us. Fur Baby's mom, good morning to you. Shirley Roth and Ann McCord, thank you for joining us. Virtuous Judah, good to see you. Green-Eyed Cat, hello, hello. The McCormick family, thank you for joining us. Amanda, yes, so Bianca Ellis will be on Monday. I called the station, and as of right now, they're still in jury selection. So they think they may start Monday. They may be able to seat a jury on Monday, and if so, we'll pick up on that. But for now, instead of doing a deep dive today, because our deep dive is going to be about 3 hours, we're going to save that for tomorrow morning at 9:30 Eastern, and then Jose Soto Escalera has his Spencer hearing on Monday at 1:30. So Monday's going to be deep dive into Bianca, then Jose, and then if they do start, Bianca will pick up on her after Jose. So we are definitely going to do Bianca. So hopefully that helps clarify that. Debbie Blair, good morning to you. Good to listen to me. Good morning. Well, it could be good morning for some people. Hello. Thank you for joining us. Nicola, good to see you. Iowa Backyard, good to see you. X was moved to regular room. Oh, good. Still trying to wean from O2. All right. Well, that's good. That's good. Glad to have this distraction. Thank you for letting us know and updating us. Fire Girl, handmade by Wendy. Hello. Can be here for a short bit, almost dinner time. Lily Wayne, hello. Great to see all of you today. Melissa Crawford and Arwen. Morning, hello, squeegees. Yes, Mimi, hello. Happy Sunday to you. So, yes, the verdict came in on Friday, and it was kind of anticlimactic because the stream we were watching didn't have it. They just had the spinning wheel, and then we found another stream, and the verdict had already been announced. So what I wanted to do is just I wanted to capture closing arguments, verdict, and then we have a press conference. So I wanted to have that all in one stream so if anybody wants to watch this trial, you know, like I said, a month from now, a year from now, 5 years from now, whatever the case may be, they will be able to watch it without having that meh that we had. So Denise, I cannot believe I missed watching this case live with you. This was in my backyard. Oh, well, hopefully you'll be able to watch the closings with us. Sally, good morning to you. Denise, we had Rose. We had somebody who lived next door or backyard neighbors with Carlos Hernandez and Amanda. So Rose was on the phone with us. She called in on Friday. So that was pretty cool. So. All right, let's get started. Let's get this started. It's going to be about 3 hours, so if you settle in, let's settle in and let's watch closings, and then we'll get to the verdict. Oh, and we have closed captioning. Yeah, see, we didn't have closed captioning before. Now we have closed captioning, so that's cool.
All rise. Oakland County Circuit Court is now in session. The Honorable Judge Cole is presiding.
Good afternoon, everyone. Thank you. Please be seated.
Calling People versus Joshua Zuazo, case number 2024-291950, FC.
John Petrofess and Andrew McGarrett on behalf of the people.
Good afternoon, Your Honor. Michael McCarthy, P30169, appearing on behalf of and with Joshua Zuazo. Mr. Zuazo is standing next to me and to my left at the table.
All right, sir, tell me your name.
Joshua Zuazo.
Okay, we're ready for closings.
Yes, Your Honor.
And we've gone through instructions, and everyone's satisfied with the packet that's
Yes, Your Honor. And the attorneys thank your staff for helping during the lunchtime break.
No, they'll appreciate that.
And
They were running around. Yeah. Okay.
Yeah, that's right.
Thank you. I appreciate that. So I believe all your jurors are, Mr. Zuazo's jurors are back, so we will bring them in, get right into it, and then instruct them.
All right, for the jury, please.
Be seated.
Please the court. Counsel. Good afternoon. All the evidence, testimony, text messages are now before you. The case is going to soon be yours to decide when Judge Polis gives you the law to take back there. You'll have a written copy to read through. I was watching something just the other day, actually on YouTube, and a guy was talking about perception versus perspective. And he was talking about how we go through life. Normally, we're looking at things as you go through it through your own perception. You know, you're seeing the events around you, the people around you. But there's also perspective, which is how are those folks looking at you? And that's stepping outside yourself and looking back. And I really thought about that coming into today's closing argument, because my perception doesn't matter. If it was my perception that mattered, I think I don't even need to make a closing argument. But that isn't what matters. What matters is your perception of the case, and that I don't know. So what we're going to talk about are things I think are important when you go forward, but it's impossible, and I'm not going to, and there's no way to do in 20, 30 minutes everything that we've discussed. It's impossible. We all have faith that you took notes. We all have faith that you paid attention. So go back and rely on that when you go forward. Now, we talked from the start about what this case is about and what this case isn't about. And from the start in jury selection, what we said is this is first-degree murder, but it's not first-degree premeditated murder. And we discussed that from the beginning. And Judge Polis will instruct you on what this is, which is first-degree felony murder. And that means, and the people have never said anything different, nor has law enforcement, that this was an intentional killing when they showed up on the doorstep on October 11th of 2024. And the judge will instruct you on the law, which is now before all the attorneys. And I'm not going to go through, there's a stack that Judge Polis will read to you, which there's no point going through it twice. But what you have to focus on regarding first-degree felony murder was that the defendants intended to commit a larceny, and that during that larceny, they caused the death of Mr. Murray by either intending to kill him or intending to do great bodily harm to him or creating a high risk that death or bodily harm could occur. And then the judge is going to instruct you about aiding and abetting, which we also talked about. And it'll say anyone who intentionally assists someone in committing a crime is as guilty as the person who directly commits it. Now, I believe the facts have shown there were 3 people in that basement. Okay, and Mr. Murray is not able to talk about what happened in that basement. But I think the facts have shown throughout this, and I think the text messages tied everything in together even more, that from before, during, and after, these defendants had planned to commit a larceny at Mr. Murray's house. And each of them played different roles and different parts, but each of those parts were going together for that same mission, for lack of a better term. And you'll hear and you've heard that Defendant Hernandez started a year before with his contact with Mr. Murray. He had personal contact at his pawn shop in Hamtramck a year before, October of 2023, where he was engaged in making pawns with Mr. Murray's shop. And then you heard, and you have the records, that in February of 2024, Mr. Hernandez appears again. And when he appears again, not only does he take some things out of pawn, but he asks to speak with Mr. Murray face to face. And Mr. Murray came over, shook his hand, looked him in the eye, and talked to the co-defendant Hernandez. And the other interesting part of that, because there are little bits that maybe don't seem that important, and maybe they're not, that's for you to decide. But what is Hernandez in there looking at? He's in there looking at Rolexes. What does Mr. Murray wear? He wears a Rolex. What does Mr. Murray have on him? He has jewelry. After that day, and as things went forward, you've seen the text messages, you've heard the connection between the 2 co-defendants, and it's a substantial connection. These are not Facebook friends who never hang out. These are not high school friends that only see each other at reunions once every 5 years. These 2 have had a close connection, and it continued throughout this time. And I think there's proof of that through witnesses and through the text messages. You heard from Ms. Diaz when she testified how the defendant, Zuazo, was going to be in the wedding in September of 2024. You heard from Ms. Diaz that she knows him by the nickname of Yogi. You heard from Ms. Diaz that she identifies the defendant that morning of October 11th when he's in the Lowe's with co-defendant Hernandez. You've heard as the testimony, the text, everything else is played out. You have lots of videos to show that they put their plan in place to physically start making it happen probably about 20 days before the murder. And you hear that through the text and through their actions. You start seeing the text that you now have today about we need a car between Hernandez and this defendant. And they go back and forth about getting a car. Why do they need a car? Well, they need a car because they want to get away with it, first of all. And they're going to do that by disguising the vehicle that they drive and then disguising themselves. They're going to disguise that vehicle after they steal it, and you've heard testimony from the victim of that theft about his car being left out and it gone, which coincides exactly with the text that you have now. You also saw texts that indicate that you need to disguise it with DTE materials. And you saw not just Hernandez walking in on video into that store to order up those signs for the sign of the car, but you saw this defendant text messaging his buddy, whether it's a male or female buddy, I don't know, but the buddy to get DTE products to disguise themselves. They go a step further, and that's to get rid of the plate, which was a very distinguished plate on the back of that truck, that POCO plate. And they got a DTE plate stolen from a DTE vehicle to make it even more unlikely that they're going to get caught if that vehicle is identified or if it shows up on a flock camera. Like everyone here now knows, is taking pictures of a lot of plates. Well, it would have come back with a DTE plate. And that disguise, as you heard, was so effective on October 11th that even Miss Niehaus, as she's walking her dog, and she said, my attention's drawn to that vehicle, first by the sound of it, and then it just seemed to be slow rolling through the neighborhood. And she said, I finally looked up and I saw it was marked as DTE. And I said, oh, it's DTE coming through to do something. And she was no longer concerned about the vehicle. Well, that's what these defendants intended. Now, you have the videos, you have the purchases at Home Depot, at Lowe's. They were getting the things that they were planning to use when they were going to get into Mr. and Mrs. Murray's house. They wanted duct tape, they wanted zip ties, they were disguising themselves as workers with different things that they purchased also at those stores. They were ready, but there was one thing that they could not buy at any hardware store for that day. And that was the will to do what was necessary. That will to go into that house and do what was necessary, you can't purchase that at a store. That came from in here. They were ready to go. And on that October 10th, when they drove there, it was this time of year, it is dark. You've got all the text before and after. And as they drive there, 40-minute, 45-minute drive, no one gets out of the vehicle. No one talks themselves out of doing what they're about to do. They're ready. They're planning, and as you saw through the text, Mr. Hernandez wants to buy a house. Mr. Zuazo is talking about needing a big score. And they had this impression that inside that house was going to be their big score. As they get to the house, and as you've heard, they approach the house, Mr. Hernandez in front, posing as DTE workers with Mr. Zuazo right behind him. And that does not, is captured on Ring video. There's the knock on the door, which catches everybody's attention inside. Mrs. Murray said she gets it on her Ring video from her phone, and Sam is already downstairs and heads towards the door. She's upstairs, and she's paying attention. So Sam opens the door. Defendant Hernandez with the co-defendant right behind him. They're trying to talk their way into the house. Mrs. Murray says, it's a little late to be doing a gas check. And then she says, Sam, do you have your gun on you? And she said, I said it loud so it could be heard. Mr. Murray doesn't want to let him in, isn't going to let him in, and doesn't let him in. Mr. Hernandez says, we'll be back tomorrow. So they leave that night, and then they have a 40-minute drive back to where they came from. Did anybody decide not to go forward with this the next day? No, there was a different type of discussion. And there's unanswered questions that we talked about in jury selection. Some of those unanswered questions don't matter. Okay? It only matters if it goes to what we need to prove in these elements. One of the unanswered questions is, why didn't they force their way in? Okay, well, they didn't force their way in is what happened. But if you remember the positioning, Sam is downstairs. He is not a small man. He's 6 foot tall. He's 300 pounds. Hernandez is in the doorway. Okay, and it's been told that he's armed. Could they have gotten to Sam before he pulled his gun? Could they gotten to Sam before he backed up and pulled his gun? I don't know. But what I do know is if they had come in that house, they could not have gotten to Mrs. Murray upstairs on that balcony before she called 911. There was no way they were getting to her before that call was placed. So they leave to regroup, and they regroup. They don't cancel it. They don't say there's Ring cameras, I'm not going to do it. They don't say the guy is 6 foot and 300 pounds. He may be a problem, No, instead they revise the plan. The plan doesn't get canceled. How do they revise the plan? Well, now they go first thing in the morning to Lowe's to get the 18-inch zip ties. So they're upping what they expect they're going to need to subdue Mr. Murray. The duct tape no longer is enough. They need zip ties, and those are the same length zip ties that the detectives described that is in the bloody scene in the basement. They have the drive back. No one gets out of the car. They both arrive. And as they arrive this time, when they're at the front door, which is captured on the Ring video, they're able to trick Mr. Murray into opening that door. Mr. Murray goes to the door, as you've heard. He lets them in, as you've heard, and Mrs. Murray is there watching this. She says it sounded like Mr. Hernandez was going to go outside, but he didn't. And you also heard that Defendant Zuazo starts lingering around where the dryer is, which is a gas dryer. So they start going downstairs, and what's important to note is the little pieces of things, which you have, I'm sure you have. So Sam goes down the stairs first. Who's following Sam? This defendant, not Hernandez. The first one to go downstairs behind Sam is this defendant. The first defendant who's going to encounter Mr. Murray is this defendant, and Hernandez goes down behind him. The door is closed, and you know some of what happens next. We don't know all of what happens next because Mr. Murray isn't here to tell us. What you hear next is Defendant Hernandez comes up, and he immediately confronts Mrs. Murray, who's right there. She doesn't hear anything for that 10 or 15 minutes. No screams, no shouts, no commotion. But she sees Hernandez, and he starts with, where's the safe, where's the money, where's the jewelry? And obviously, that conversation triggers the realization that these are not DTE workers, that this is a problem. And she answers immediately, we don't have a safe, the money's in the purse, there's no real jewelry here, it's upstairs. And you hear at that point in time, Defendant Zuazo comes upstairs. And when he comes upstairs, Sam isn't with him. And when Mrs. Murray sees Zuazo, she asks, where's my husband? And she's asking, where's my husband? And he comes up and hears that. Hernandez doesn't say anything in response to that. Zuazo does. And what he chooses to say is, he's sleeping. And at that point, she sees the blood on this defendant's chest as she starts screaming. Hernandez immediately punches her on the left side of the face, as you've seen the photos and as you've heard in testimony. And what else does Mrs. Murray say that is important? And as you look back through everything, all that we ever want is for you to use your common sense about what makes sense, what doesn't make sense. And what makes sense is exactly what she says. She says she sees his whole face because the mask is no longer in position. And what makes sense about that, because he's trying to disguise his face with the mask, both on the 10th and on the 11th, but why it's not in place anymore is because he had just been in a struggle with Mr. Murray down in the basement. And that mask had been moved and dislodged during that life and death struggle. And that life and death struggle was just Mr. Murray's life and death. These defendants were never concerned about their life or death. And if you heard, the only blood, there's DNA from the defendants. There's never any blood from the defendants. The only blood that you see, and there's a lot, is from Mr. Murray. Now, she sees his face, she describes him to the police officer, she describes the facial hair, and you heard the officer yesterday testify when he was arrested, he had facial hair. And then you've seen the Lowe's video from that morning where the defendant is there with Mr. Hernandez with facial hair, with the bucket hat that's later found. So does that end it? Does the defendant head for the door? Does he say, I'm getting out of here? No. Where does he head? He heads upstairs to continue the mission, which is to find the jewels or this treasure that doesn't exist. So he goes upstairs, and you heard that when he goes upstairs, those rooms are ransacked. You saw those rooms are ransacked. The costume jewelry is every place. And you also heard Mrs. Murray testify that Hernandez never went upstairs. Only this defendant went upstairs. And what else is upstairs? The victim's blood on that swipe on the wall. Because there's so much blood that was downstairs, the defendant got the blood on him and left it upstairs. As that's going on, Mr. Hernandez is still looking for items, trying to get into the purse, trying to take the car keys, taking the cell phone, taking all these things, and the gun is missing. Gun's never been found. Last time it was seen, it was going downstairs with Mr. Murray. That gun is missing. Mrs. Murray tells you that she's bound up by the duct tape. You saw how Sam is bound up in the basement. He's not just bound up with duct tape, he's bound up with the zip ties that they have just purchased. And then you hear this defendant returns from upstairs, wanting to go. We need to go. But what does he want to do? This defendant, he wants to put Mrs. Murray in the closet. He wants to put her in the closet before they go. And he starts trying to do it with Hernandez, but she's duct taped in a position that she can't be moved into the closet. So as much as they tried to even do more, they weren't able to. So they depart and flee. It's not over, because they got to try to get away with the little that actual value that they took. The only thing of value that they took that day was Mr. Murray's life. That's the only thing of value that was taken. The rest was junk. What do they got to do? They got to go get that truck down in Detroit, and you saw the text messages where it sounds like it's pre-planned. You hear that they set that truck on fire to burn its contents, burn any DNA that's inside the truck, and then it's time to get out of there. Hernandez gets home. You've heard the testimony that he quickly packs up that Jeep, packs up his wife, packs up her child, and they start headed down south. Now, when they get down south, they don't have much of a drive before law enforcement is quickly on them. Law enforcement finds a lot of objects of value that are later processed. You've heard about all those objects, which include the 13-size shoe, which is Mr. Hernandez, and in fact, the video, you can clearly see he's wearing those Nikes in one of those videos. You also have the brown boots that are size 11 that are not able to fit Mr. Hernandez's foot. And you also heard today that the defendant's shoe size is 10.5. And I don't know about anybody else who buys shoes, but my shoe size range it's a large range between what brand you buy. 10.5, 11, 10, they all can fit the same foot, as everyone knows out of their own common sense. So they find the bucket hat that belongs and is seen on the defendant. You also find the jewelry items that were taken by the defendant. All of those things, plus more, are found in that vehicle. Now, at that point in time, the attention of the sheriff's office has quickly been focused on Mr. Hernandez and this defendant also. You heard from Mr. Broad, who calls into the sheriff's office and says, I know that guy. He testified yesterday. I know that guy. I worked with that guy. He identifies him from the video. He identifies the clothing from the video, and he identifies those boots being consistent with the type of boots that are used at their scene. So then you hear more gruesome details today from the medical examiner about the manner that Mr. Murray was killed. Those photos show a lot of light about what happened in that basement. It was a brutal beating, a multiple hit beating, a beating that could certainly have occurred with two people, regardless of their size, But when we talked about the Rolex, it's important when I think about things about how did it physically transpire. He has 2 strikes to the back of his head from a blunt object, consistent with a gun, consistent with a lot of other objects that could cause that type of injury. Okay, so Sam goes down. They ask for the safe, maybe. He's not giving an answer, maybe. He says, I don't have anything, maybe. But you know that conversation occurs. It occurs upstairs, and they don't like that answer either. So Sam is struck and he's bleeding. But he's not quitting. You heard Mrs. Murray talk about he's a strong man. You've heard he's a big man. And he's not unconscious, because if he's unconscious, how could I say that? I wasn't there. Well, because it doesn't make sense with the rest of the facts in the case. If he's unconscious, you don't have to bind him up like that. You don't have to duct tape him. You don't have to duct tape his mouth. You don't have to zip tie him. This is a struggle at a minimum with Mr. Murray and the 2 defendants. And what else do you hear? That as much as Mr. Hernandez loves Rolexes, as much as the only thing of financial value in that whole scene that day was probably that Rolex, what happens during this struggle? This struggle occurs to the point where he's duct taped and zip tied where you can't even get to the Rolex. If he was unconscious, if he was the first thing that comes off is the Rolex. Maybe they try to get the ring off, but the thing of value is that Rolex. Can't even get to it, but they don't care because they're in a struggle with him. Now, that beating had many injuries to Mr. Murray that you've heard about. And we talked to the medical examiner about the compression to the throat and about if someone's struggling to break that compression, whether it's a knee, a hand, a foot, it would reset your clock. If someone's trying to choke you, you knock it away, it resets the clock. Keep doing it. So I believe it's taking 2 people to try to restrain Mr. Murray. And that fact is borne out by the fact that you have blood on both defendants. There's no version where any defendant left that basement before that violence occurred. Impossible, because you're not getting blood on your boots, you're not getting blood on your Nikes, you're not getting blood on your shirt. Both shirts. Because the t-shirt Mr. Hernandez has tested also has the DNA on the blood. So that battle is going on down there. And, I try to think about it like just normal life, okay? I have a brother 4 years younger, okay? So growing up as kids, when we would roughhouse, wrestle, things like that, there was a point in time where I could get both of his wrists in one hand. And I could put him down with one hand and hold him in place. And then I had one hand free. That stopped when we were about 12 years old. I could no longer control him with one hand. There was no way one person was controlling Mr. Murray all by themselves to both tie him up, keep him in a position, do all that. That doesn't seem to me to be reasonable. I think Mr. McCarthy is going to say a few things at this point. Give him your direct, full attention like you have throughout this trial, and then I'll have a few minutes afterwards to address what he says.
Thank you. Mr. McCarthy.
Thank you. Good afternoon. I want to thank you, first of all, for paying attention during the course of this trial. I talked about that in my opening statement. I think I may have touched on it a little bit while we were conducting the jury selection on Monday, but I did for sure talk about it in opening statement about how important it is to pay attention so that the 12 of you that are ultimately chosen to go back into the jury room and deliberate will have all the information you need in order to actively participate in those discussions. And I'm convinced that all 13 of you here present today, this afternoon, have fulfilled the solemn obligation of your oath. And on behalf of Joshua Zuazo, I thank you for having done so. And now it is, in a short time, going to be your opportunity as well as your obligation to do the one thing that brings us all together here, to discuss the one thing that brought us all together here this entire week, and that is to determine what the facts are. As I said in my opening, I'll repeat again, that a trial is a search for the truth, and you all are the truth finders. You are the people who are going to make a determination based upon the evidence presented during this trial of what that truth actually is. And then ultimately the practical reality of those decisions that you make in coming together and determining the truth is going to be whether you find that there's been evidence presented to the high standard of proof beyond a reasonable doubt to convince you that Mr. Zuazo is guilty of any one of these 3 crimes with which he is charged and for which he has undergone a trial before yourselves. First-degree felony murder, unlawful imprisonment of Hussein Murray, and unlawful imprisonment of Linda Murray. One of the things that impressed me about the evidence that we have heard, and one of the things that I told you in the very beginning of the trial, is that this is about identification. And I understand Mr. Petrofess's argument, and he is attempting to convince you beyond a reasonable doubt that that second person who's there with Carlos Hernandez in the Murray home on the 10th day of October in the evening, and on the following morning, the 11th of October of last year, is Mr. Zuazo. But there's quite a difference between what you're able to perceive in all of the videos that have been shown to you, in which, are exhibits, and you are all welcome, as Judge Polis will tell you, any exhibits that you want to see, you're going to be able to see again and go through them. And I encourage you to do that very thing, especially from that Friday when it's daylight and you can see. And take a good look at who that second person is. And ask yourself, is that really proof beyond a reasonable doubt that it's Joshua Zuazo, or is it somebody else? Because when it comes to identification, besides what you can see just in little clips from those videos, comes from Mrs. Murray and Kelly Broad. He testified yesterday. I believe it was yesterday, it might have been Wednesday. But whichever day it was, he testified during the trial, and he is the person who used to be Mr. Zuazo's supervisor, 2 levels up from him, but some sort of a boss at the St. Mary Cement Company. And I don't know about you, but I had a little difficulty following what he was saying. I know he was here for a reason. First of all, he was subpoenaed, so he's obligated to be here. But he was here to make sure that who he says had threatened him when he fired him got convicted in this crime. He says that he knows it's Mr. Zuazo because in the video he is wearing Wolverine steel-toed boots given to him by St. Mary Cement Company. And he's wearing safety glasses. Prescription, he says, given to Mr. Zuazo by St. Mary Cement Company. So the thing that I ask you to do is scrutinize what he had to say. And the reason I say that is because in the instruction that the judge is going to give to you a second time, she's already given this to you once before the evidence presentation began, is about witnesses. and sizing up the witnesses and making a determination about who you believe. And one of those things that she's going to repeat is words to this effect about, does the witness try to actually answer the questions, or does the witness argue with the lawyer? And I would add this: does the witness ask the question presented? Now, I've been doing this job of representing people in trial and conducting litigation in civil matters as well as criminal matters for 45 years. And so I consider myself pretty capable of keeping people on point and getting them to answer the question that I put before him. Ask yourself in your memory how many times I had to repeat a question and ask him to answer the question that I put to him. Was he honestly trying to answer the lawyer's questions, or was he arguing with the lawyer? And this is a huge piece of evidence that is presented specifically to fill in some gaps about who that second person is and make it be Joshua Zuazo. I submit to you that Kelly Broad was not honestly trying to answer the questions. He was here with an agenda. He claims that Mr. Zuazo threatened his life, but he never reported that to the police. And he says that he can tell that these are Wolverine boots. The fact is, when I asked him the question, I says, well, all you can see is down at the bottom. The person who's wearing those shoes is wearing long pants. How can you tell all these things? Well, he just knows that that's true. Well, if that's so true, and the people's theory about Mr. Zuazo's presence at that place, the home of the Murrays, then how come there aren't some brown Wolverine steel-toed boots in Mr. Zuazo's house when it is subjected to a thorough search? Why aren't those steel-toed Wolverine boots that Mr. Broad is so certain were present in that video in the Jeep that is racing from Michigan to Texas and is stopped in Louisiana? Those are Timberline boots. And there's no evidence that those are Mr. Zuazo's boots. There's no DNA in those boots that says it is Joshua Zuazo's DNA. There is DNA that says that the blood on top of one of those two boots is Mr. Murray's. No question about that. Who is to say, what evidence is there that is reliable that it's Joshua Zuazo whose feet were in that boot? Where is this shirt that Mr. Broad claims he recognizes as a St. Mary cement shirt or covering, whatever it was, this yellow looking thing that you can see in the video? How do you know that that's from St. Mary? When I told him that there was this in the video that I watched of him, on his shirt he had a name tag, or the company name is what he said. I couldn't see it very clearly in the video I watched. But he explained, yeah, he says that's St. Mary Cement Company says that on this green patch. And then he adds in, well, of course, those can be easily removed. Okay, well, there wasn't one of those on that shirt, and he claims there's this thing on the shirt, though, that says fire repellent. I think was the two words, FP or FR, and so there'd be some kind of safety shirt that the St. Mary people have. He claims he can see that in that video. I encourage you to take a good look at that and see whether that's what you see. Or is what you see a name tag holder, a clip of some sort, something like all of you have for your jury badges, up there on that shirt that this second person was wearing, and not some initials from the St. Mary Cement Company, but just the clip to hold on to the fake DTE Energy tag. Question of fact for you to decide. Then we have the fact that the other person making an identification of Mr. Zuazo is Mrs. Murray. She's a compelling witness. And who among us would ever want to be in her shoes? And this was without question, and she honestly answered this for me when I cross-examined her a couple of days ago, the terrible, traumatic situation, an experience that she's never had before, of course, and is living with to this day, and cannot get it out of her mind, and thinks about it all the time, and certainly has it on the forefront of her mind because she had to come here and give this testimony. And she's here present and has been throughout the time that has passed since the time she gave her testimony. And so one of the other instructions you're going to get is that you cannot let sympathy or bias or any human emotion enter into your decision making. And I ask you to think about the two witnesses from the Oakland County Sheriff's Department who testified yesterday, Deputy Hagelin and Deputy Wigman, about the description of the second individual that Mrs. Murray gave when they conducted interviews with her. Deputy Hagelin was not the first person who saw her. That was Deputy Copeland, who was the first man on the scene. And his interaction with her was rather brief, and he got her out of harm's way, or at least where he hoped it was going to be out of harm's way, so that he could summon more deputies, and he didn't have much interaction with her. Deputy Hagelin took her and put her into a vehicle, a police vehicle, for her own safety and to give her an opportunity to be sitting down and out of all of the activity that was going on in her home and talk to her. And what she told him was that it was a person of average size, black male, but a person of average size. Didn't give any specifics. That was the same thing that she said to Detective Wigman, who saw her more often. He saw her in the hospital emergency room on the 11th and then of October, and then he said 2 or 3 or 4 other meetings after she was discharged from the hospital that day in the following days, and those meetings were conducted in the home of her son. But never once did she give a description to say that Zuazo, or the second person rather, who she has now identified as Mr. Zuazo, was 6 foot tall. It was always a black male of average size. Now, she was specific in her description to Detective Wigman about who is, we know, Mr. Hernandez. Very tall and fat, very fat. One of the pieces of evidence that's been admitted during the course of this trial is that when Mr. Hernandez was racing away from Michigan to Texas, where he thought he could hide out until he was stopped by the Cato Parish Sheriff's Department in Louisiana, Shreveport, he got taken into custody, and as is the custom or the protocol for putting a person into custody and incarcerating him, they take some statistics or information regarding that individual, and they have him booked in at 6'6" and 450 pounds. Now, going to the basement of the home of the Murrays on the morning of October the 11th of last year, there was a person weighing 450 pounds who was very capable of squeezing the life out of Hussein Murray by using his foot, using his knee, using his hand, because no matter how you press down, what part of your body when you're that big, you press down with your knee, your foot, your hand, you're going to have 450 pounds backing you up. And that is a tremendous amount of weight. So when we have this compression, because that's the cause of the death, is his neck compression, not only does Mr. Murray have a fractured jaw, but he has his hyoid bone right up here in the top of his neck. And that is an essential thing you need in order to be able to stay alive. His gets fractured not in one place, but in two spots. It's crushed by somebody's sustained effort to do that. Why is that going on? Who is intent about doing that? Well, I would suggest to you that the person who's text messaging back and forth between himself and his new bride, Mr. Hernandez, talking about getting a house, hope we have a good score. She's helping him plot this crime that he's committing. And remember, it isn't just a house, our house. Starting out, this young married couple with this dream of having a house will go out and commit a crime that includes a murder in order to have one. But also, not just any house. Look at those text messages that were admitted, I think, as exhibit number 22, but they're all in there. A house with a nice yard. I don't know why the plotter, the planner, who's up to her eyeballs in this thing, Amanda Diaz Hernandez, the new bride, is not sitting over here at the defense table. But that's not my decision to make. But if anybody is involved in a conspiracy to commit this robbery, this stealing of property from a person who they know to be, they being Hernandez and his wife, to be a man of property because he owns a jewelry store and he owns a pawn shop in Hamtramck, and then, you know, he's out there scoping out the house, and you can all see, as bad as the pictures are, given the circumstances under which they were taken, the home, the Murray home, on the 10th day of October was a beautiful place where the upstairs wasn't ransacked. And you can tell they had very nice furnishings and everything was properly appointed. And it was a big house with not one but two stairways. So they've got this man targeted. And you heard Mr. Petrofessa say that Hernandez was over in that pawn shop asking to talk to and meet Mr. Murray. Why is he doing all that? You got any evidence presented to you about Joshua Zuazo pawning stuff at this place, going in, asking to talk to the owner? No. And who is the man in the forefront all the time? It's Hernandez. He's the guy right up there to the front door. He's the guy with the clipboard. And when the police come and they do the search at that house in Lincoln Park that mother, Danielle Diaz, who had the bad leg, was here yesterday with a giant chip on her shoulder, a little difficult to talk to also. When they come and they do that search, among other things, they find the DTE Energy cutouts designed by, apparently, one of the two of them, or maybe both of them, worked on it together, a kind of a joint project of a young married couple, so they can have their dream house. And that's not in Mr. Zuazo's house. It got searched thoroughly. You don't see one piece of evidence in this trial that came from Mr. Zuazo's house. But there's a lot that came from Hernandez's house. How about that white shirt in the back seat of the Jeep, or the back of the Jeep, that's got Mr. Murray's blood on it? Now, you know, I made a point, and I'm not trying to make fun of somebody because they're overweight or big. I mean, this is only because it's an essential fact in this case. It's a 6X, and his DNA, Hernandez, is in the collar, you know, of the shirt. And if it's his shirt, then that just makes perfectly good sense. But the blood, that is Mr. Murray's. There are no clothing items. There is no evidence that connects Mr. Zuazo to Mr. Murray's blood, period. There are shoes, size 13, in the back seat, or in the back of that Jeep that are taken into custody by the Cato Parish Sheriff's Department and then handed over to the Oakland County, Michigan Sheriff's Office. And those are analyzed. We had the testimony. Witness here, I believe it was yesterday, Ms. Ramirez, and it's up in the octillions, for one in so many octillion that it's Mr. Murray's blood on Mr. Hernandez's shoe. There's the black gloves. There's black gloves seen by Mr. Hernandez, or on Mr. Hernandez during the crime. And what do we have in the back seat? His DNA inside those black gloves. No question he was there. No question that this horrible crime was committed and that he is responsible for it. And this whole idea of all this was supposed to be as a robbery. Well, I can't tell you what's in somebody's mind any more than Mr. Petrofesa can on the day that this happened, this horrible, tragic, criminal thing occurred. I don't know what Mr. Hernandez is planning on doing. But I do know that, well, there's no doubt, no reasonable doubt, that he is responsible for all of those things that happen. There is no such evidence beyond a reasonable doubt that it's Mr. Zuazo. Let's look at one other video. It's at the Lowe's. It's at 9:30 in the morning, and it's down in Allen Park, I believe. And that video shows Mr. Hernandez walking around inside the store, and then he's buying items, and then he pays for those items. There's another person with him. The people allege and argue that it is Mr. Zuazo wearing this bucket hat. And the bucket hat gets found in the back seat of this Jeep. Now, I'm not much of a hat wearer. I have a couple of baseball hats, but that's about it. I understand, though, that there are people that like that type of style of hat, and I guess in sunlight or sunshine, warm days, maybe it's a good thing to have. Keep your face from being burned up or your neck. Well, whatever the reason somebody's wearing it, if it was Mr. Zuazo, you would think that there would be some DNA on that hat, on the inside of that hat, for this person who's wearing it. If, in fact, that's who it was. We don't have that in evidence. We don't know whose hat that was. We don't know who was wearing it. We don't even know, really, whether the person who was wearing that hat left that hat in the back of the Jeep. But we have one other thing, and that is a number of items taken from the Murray home, stolen. Any of those at Mr. Zuazo's house? Any item from the robbery, the larceny rather, that took place as the predicate felony to charge first-degree felony murder in the hands of or anywhere near where Mr. Zuazo was? No. Let's talk a little bit about leaving town. This Mrs. Diaz, the mother, Danielle, testifying yesterday, she doesn't really know when they left. And they were going to leave. They were always going to be leaving, but all of a sudden they were going to be leaving maybe that day. She was asleep because she works these long hours, so she doesn't want to give you too much information. She surely wasn't, I would say, a cooperative witness. I wouldn't tell you that she lied absolutely, but I wouldn't put a lot of faith in what she had to say. But I got thinking about the newlyweds, and what I didn't hear about from either one of them, even though they have this desire to have their own house, is that either one of them had a job. We got some text messages about being behind on the rent by 5 days on the house down in Texas, or the apartment, or whatever kind of a residence it is. And then, the response is, yeah, well, we spent all that money in PR, which I imagine is Puerto Rico, but I don't really know. Probably the honeymoon. And so, no job, no means of getting the dream house or even putting food on the table. What's going on here with Mr. Zuazo? Where is he when he gets arrested? Monday morning, October the 14th, or maybe it's the afternoon, but sometime on that day when the fugitive apprehension team comes to the job site where he's working. He didn't leave town. He didn't go anywhere. He's here, easy to find. The only reason they find him is because of this Kelly Broad coming in with his chip on his shoulder to identify him and say, well, I think this is the guy. Getting even for whatever it was that he's not happy about. But Mr. Zuazo's not down in Cato Parish, Louisiana, heading to Texas. He's not getting on a plane to fly to Europe or something like that. He didn't go anywhere. Well, now why would he just be sticking around while Hernandez has gotten out before the day is over? He's on the road heading home because he doesn't have a guilty conscience. He didn't do anything. He's got nothing to run from. Let's go back to Lowe's. 9:30 in the morning. You have this video. Maybe it's Mr. Zuazo in there. That's going to be for you to decide. Let's say, for argument's sake, that it was him. That doesn't prove that he went anywhere beyond that place where that store where Mr. Hernandez made the purchases or paid for whatever it was he got. And what do you see with Zuazo? What's he got? Bottle of pop. Look at those videos. Or a bottle of something. I can't tell you it's pop. Look at those two receipts, the one from Lowe's, the one from Home Depot. There's some sort of drink in both of them. There isn't any question that these men know each other. The question is, were they there together that day at the Murray house? Are they both responsible? And certainly Hernandez was. But is Mr. Zuazo with them then? Not at 9:30. There's no crime committed at 9:30 in the morning down in Allen Park. Is he responsible for the wrongdoing in which Mr. Hernandez was engaged at 11:30 to noon later that same day, the 14th day of October? That's the question. That is the key question of fact in this case. Now, in the instructions you're going to receive, you've heard this once before, and you'll hear it one more time by Judge Polis when she gives her final instructions. But it's the instruction about presumption of innocence, burden of proof, and reasonable doubt. And I ask you to keep this in mind because she's going to say this to you. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. And then it goes on to say a reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It's not merely an imaginary or a possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that. A doubt that is reasonable after a careful consideration and careful and considered examination of the facts and circumstances of the case. This is essential to making a determination of the truth here. You have to be firmly convinced that Mr. Zuazo is guilty of any one of these three crimes, because the same standard applies to each crime charged, and you have to consider each crime charged individually. But no matter which one you're deliberating upon at a given time during those deliberations or discussing, think about that. You have to be firmly convinced that he's guilty beyond a reasonable doubt. We haven't seen that level of proof. Firmly convinced. There's a big question here raised about identification. And I told you in the beginning that this would be the key to the defense presented. They have the right guy. And when she instructs you on this particular point of law, Judge Polis is going to say, among other things, in deciding how dependable an identification is, think about such things as how good a chance the witness had to see the offender at the time, how long the witness was watching, whether the witness had seen or known the offender before, how far away the witness was, whether the area was well lighted, and the witness's state of mind at the time. So, in the case of Mrs. Murray, this has particular relevance because her state of mind at the time would be one of terror. Whose state of mind wouldn't be that way? She had interactions with the police. They were back to see her multiple times. She's the only eyewitness. So she's a very important person, and I think it would be very difficult if I was a detective investigating this case to have to bringing up this wound with Mrs. Murray so soon after it happened and asking for more details. But they have nowhere else to go to get this information. And in the back and forth, the trading information, she comes to have an understanding of who it is that the other suspect is. And so she's able, without question, you know, when she testified here very clearly, she's able to use names. She knows who the defendants are, without question. And she can certainly identify Hernandez. But I submit to you that she has adopted an understanding that Mr. Zuazo, because he is the defendant, is actually the person who was there in her house. She's testifying honestly. She's simply mistaken. And I think that that is a common enough thing that can happen to a person who's a victim of a crime. And even if she wasn't a victim herself, although she was or is, for the unlawful imprisonment perpetrated by Hernandez, who tied her up with duct tape, she's got all that trauma to deal with. So that could have an effect on her ability to recount the events completely accurately and to be able to identify Mr. Zuazo. Now, there's something about blood on the sleeve of the person, the second person, but we don't have that in evidence. So we don't know whatever happened to that sleeve, the shirt it was on. It's just not before you. It's something that was seen. And there's another thing, there's some blood on a wall upstairs, a blood mark. I didn't hear any evidence about any DNA being taken from that stain on the wall. So while one might, under circumstantial evidence, because you'll get an instruction on that as well, be able to say, well, you know, this is a blood mark up there, and there's this horrible thing that happened, and maybe that blood is Mr. Murray's blood. And maybe it is, and maybe something happened where some accident occurred and there was some blood that ended up on a wall that didn't get cleaned up immediately. I mean, I know there's been things in my own home that have gotten messed up that didn't get cleaned up immediately. Sometimes you don't notice something, and it's quite another when the police investigators, I think that Ms. Myra testified to like 15 people being there on the afternoon and into the evening of the 14th of October last year. They're going to see everything. They're looking everywhere. But how long that was there, we don't have any testimony to that. We certainly didn't hear Miss Murray say, well, you know what, I never had anything like that there before. It wasn't there that day. That wasn't the testimony. At least it wasn't touched upon. Reasonable doubt? Whoever went upstairs did ransack the place. It's all terrible. It's a horrible tragedy. I, even though I'm an advocate for Mr. Zuazo, because I'm not a juror, can at least allow myself to have compassion or sympathy for Mrs. Murray. You all can't do that while you're deliberating and thinking about what the facts are. You have to use what I told you about in opening statement, or my opening statement, is that cold-eyed calculation to come to a determination of what the truth is. I know that's what you're going to do when you deliberate. I appreciate all the attention that you've paid to me here this afternoon, all the time, that you have, all the attention you paid during the course of what is now the fourth day of our trial, all 4 days. I've done everything that I can do for Joshua Zuazo. I'm going to sit down in a minute. And Mr. Petrofessa is going to get up and attempt to poke holes in what I've just told you here this afternoon, because that's the way the system works. And he gets to talk twice, and I only get to talk once, because he has the burden of proof. And so he gets the opportunity to give a rebuttal argument. And that's the way the rules work, and it's perfectly fine. I'm confident in that burden of proof business, and I am very confident in proof beyond a reasonable doubt that you will find in Mr. Zuazo that hasn't been proved against him, and that he would be found not guilty. But when Mr. Petrofessa makes his points, I ask you to keep in mind those things that you anticipate after I've talked so long that I would have said, given an opportunity to get up again, which I won't have. And as I told you a moment ago, I've done everything that I can do for Joshua Zuazo. And now I leave him with you and in your capable hands. Thank you. Thank you, Your Honor.
You're welcome.
My goal now is to stop talking about 60 seconds before everyone stops listening. You've heard a lot. It's been very intense. The closing arguments have been long and also intense. So let me start by saying, in a response that wasn't how I was planning to say it. Mr. McCarthy, I've known for a long time. He's an excellent attorney. He's an ethical attorney. He would never intentionally mislead you from something that has occurred during the trial. A lot of stuff happened yesterday. A lot of DNA evidence came in, and I believe Mr. McCarthy misspoke just now in his closing. Mr. McCarthy said that blood swipe upstairs was never DNA tested. It was DNA tested. That was in the lab test number 5 that we had testimony about yesterday. It's exhibit number 8E. It's the upstairs wall swipe, and it comes back to the victim, Sam. You have the report, and that's enough. And I don't believe, and the same thing, if I misspeak on something, it's not intentional. I know Mr. McCarthy's wasn't intentional, but what he said wasn't correct. That was tested. Now, a couple other things that he mentioned was about missing evidence. Well, you know what the defendants did as soon as they left the residence that day. That was to go destroy evidence. So I don't know what was burnt up in the vehicle, but they attempted to burn up the vehicle, destroy DNA evidence. You know, a lot of things weren't recovered that were taken. Cell phones weren't recovered. The pistol wasn't recovered. The cash wasn't recovered. And Mr. Hernandez left town immediately because he had someplace else to go. This defendant was still here, but he had several days knowing what was going on, knowing what was in the paper and on the media to get rid of any evidence that he may still have had, so it wouldn't be as residents with the sheriff's office showed up. So it's not surprising that there wasn't any additional evidence that was found there at the house. Now, there's certain things that, when we talk about Mrs. Murray, when we talk about the witnesses, that it's beyond common sense, it's beyond reason when you're looking at things. It's impossible. Just certain things about this identification of this defendant would be impossible to have happen if it wasn't accurate. I don't have to prove impossibility beyond impossibility, but it's actually impossible in my estimation regarding Mrs. Murray's identification. She says, square away, I saw his face when the mask dropped. She says that. She identifies the defendant. She identifies him under oath back in December of last year, says, I recognize him from the house. Okay? Now, what's impossible about that identification if it's a misidentification? Well, what's impossible about that misidentification when she says it a year ago, when she says it under oath? What's impossible for Mrs. Murray to know? It's impossible for Mrs. Murray to know that the defendant's DNA is going to be found in the basement of her house. That's impossible. And if you notice, the one thing we didn't hear, although we had opportunity to discuss anything, was anything about the defendant's DNA on that duct tape. Two sets of duct tape in the basement of that house. That wasn't discussed. That's identification. What else is impossible? Well, when Mrs. Murray is making that identification, she doesn't know if there's a connection between Hernandez and him. She doesn't know that they go back. She doesn't know that there's all these text messages. What if the investigation went back and it wasn't that? What if the investigation went back and it was somebody else's DNA in the basement to discredit that identification? No. Everything that goes forward says this is the right guy. And what else you have that can't be created? Mrs. Murray doesn't know that Ms. Diaz is going to know the defendant, that she's going to know the defendant and his connection with Hernandez. It's impossible for that connection to have been known by Mrs. Murray when she made her identification. It's impossible. And what else is impossible is that Mr. Broad, when he testifies, he says, yes, I also know him by Yogi. Impossible for him to know that Mrs. Diaz, who's also going to identify him, knows him as Yogi. It's going to be impossible that he knows the connection with Hernandez. Hernandez is the obvious guy on the video. But he doesn't know that. He never has talked about Hernandez. But he knows the defendant. It's the rest of the investigation that brings everything together, that all these are connected to the defendant. It was also said at one point that on October 11th at 9:30 he hadn't done anything wrong. You've seen the planning that had gone through this case way before the 11th. You had seen the planning that this defendant did to get the DTE items, to get the helmet, to get everything else that was needed to be impersonating DTE officers to get into that house. So we're supposed to believe that somehow he does all this preparation work, that somehow he's identified by all these witnesses, but somehow there was somebody else who was there with Hernandez on the night of the 10th, and then suddenly that person disappears and he's the one who goes with him to Lowe's, and then suddenly he disappears again. That's not reasonable, and that's not what the facts are. I'm going to end it here, but I believe when you go back, you're going to conclude this is the other person who was there, as the testimony, the DNA has said, and that the defendant is guilty as charged on all counts. Thank you.
Okay, thank you. Members of the jury, the evidence and arguments in this case are finished. I'm going to now instruct you on the law. That is, I will explain the law that applies to this case.
All right. Excuse me, you guys spoke, so we're just going to stick with closing arguments from both sides, and then we'll get to the verdict. I'm going to fast forward through here, and we are going to get to the closings for Hernandez.
All rise.
Thank you. You may be seated.
Calling people versus Carlos Hernandez, case number 2024-291945 FC.
John Petrofessin, Andrew McGarrow on behalf of the people.
I see you.
Paula Michelle Lofton on behalf of the defendant, Carlos Hernandez.
Can I tell me your name?
Carlos Hernandez.
Okay, we're ready for closing then?
Yes, Your Honor.
Okay, we will bring in Mr. Hernandez's jury. You can come right in here. Welcome back. Please be seated. Ladies and gentlemen, I apologize. Obviously, my estimation was significantly off, but we're ready to go. Go ahead, Mr. Petrofessa.
Anything support? Counsel? Good afternoon. There's been a lot of evidence, a lot of testimony, experts who've testified. It's been a very intense 3 days. I understand that. Ms. Lofton understands that. And as I stand here before you, I'm always thinking about what do I say at the end of the case when I know you've all paid attention. I know you've taken notes. And I actually saw something on TikTok last week that made me think about this, which was a guy was talking about the difference as you go through life between your perception of things, which is how you walk through life and you look from your set of view to what's going on around you. You see your family, friends, work. That's your perception. But there's the perspective. If you step out of yourself to look back at you in that picture, you in the group of everything that's going on around you. And that's really what I think about now, because from my perception, I don't need to make any closing argument at all. I believe you've paid attention. The judge is going to give you the law. I really don't need to say much more than what you already know. But I don't have your perception of what's going on. I can't assume that. So I'm going to say a few things about the case and see if I can address things efficiently. I'm not going to go through everything that you've heard in depth because we could take another hour to go through the text messages like we did this morning. You've paid attention. I'm going to try not to be redundant on things that you've already incorporated in your view of what's been going on in this courtroom for the last 3 days. The judge will instruct you on the law, and we talked about it in jury selection, and it is a first-degree murder case. But to be very clear, it is not a premeditated first-degree murder case. That is, I don't have to prove premeditation. I don't have to prove that on the night of October 10th or the day of October 11th last year, they intended to kill Mr. Murray. That's not what this charge is. That's not part of my proofs. All I have to show regarding felony murder is that on that day, on October 11th, their intent was to commit a larceny. And then in the commission of that larceny, as they were doing that larceny, as the judge will instruct you, the death of Mr. Murray was either because they intended to kill him, or they intended to do great bodily harm, or created a very high risk of death or great bodily harm in that commission of the larceny. And you're also going to hear, which we also discussed during jury selection, anyone who intentionally assists someone in committing a crime is as guilty as the person who directly commits it. And as you know from everything that's been presented, on October 11th, 3 people went down into that basement, but only 2 people returned from that basement. And I cannot tell you what Mr. Murray saw because he's not here. I will tell you that what you've seen in this case, especially today with the text messages, I believe it shows very clearly that this was a plan both before, between the defendants, during, and then after. And the plan was to get rich by robbing the Murray's home that day. They had a belief, which was false, that there was a lot of valuable things in that house. And there wasn't. The only thing of value that was taken on October 11th was Mr. Murray's life. That's the only thing of value. The rest of it is almost junk as far as value. A cell phone, some cash, junk. But that's what their intent was. And that intent as you've heard, started in the process, in the works a year earlier in 2023 in October, almost exactly a year earlier, when this defendant started to have his dealings with the pawn shop of Mr. Murray and Hamtramck. He would go to that pawn shop, he would pawn items, he would get cash, he would have contact with that pawn store, and then you heard in February of 2024 he returned. And when he returned in 2024, as you heard from Hannah Hussein, he asked, as he was looking at the Rolexes, and the Rolexes, I think, have a secondary importance when you see what happened and what you saw happen at the scene. He sees the Rolexes, he spends a lot of time, 10 minutes, looking at the Rolex case, and then he asks her to see the owner. And she brings the owner to him. And the owner looks him in the eye, shakes his hand, introduces himself as he's wearing a Rolex, as he has a necklace on, and that's a solid identification of how the first connection between the defendant and the victim occurs. And you heard in that statement that was played yesterday, when he's paddling everything he can to stay above water down in Cato Parish, and he throws out there, because the detectives don't have everything at that point. It's very fast. The investigation happened. It was successful, identifying the defendant very quickly. And part of it is from the obvious. You don't have to have known the defendant for your entire life to see that Ring video and say, oh, that's the defendant. Very distinctive. The focus was on him quickly. But in Cato, if you remember what he starts saying, well, this was set up by some third guy. He starts coming up with this. He was identified, the victim was identified by a third guy. No, it's not a truthful story, and you're trying to get yourself as far away from what happened as possible. In fact, you knew the victim directly. You saw the victim directly. And at that store, as you heard, Mr. Murray's Audi was always parked in the same location outside that store, visible to folks who would come and go, just like it was parked visibly in front of his house. You hear that as time develops, and he's back here in 2024, in September, you start seeing very clearly by text between the two defendants about creating this plan to get into Mr. Murray's home. And they also intend to get away with it. They're not trying to get caught. They plan on getting out of there. And what, as you see through the text, tightly linking it, what are they going to do to get out of there? The first text between the defendant and Zuazo, and also Amanda, has to do with stealing a vehicle. He texts, we need to steal a car. Okay, why is that? Well, because he doesn't want to show up in Rochester Hills in their in their Jeep, with their plate on that Jeep that can be tracked back. As we all know, the Flock system tracks plates like that these days. I had no idea Lowe's tracks plates like that these days also. So license plates are a very quick way for law enforcement to identify folks. So they're on it. They're planning to steal a vehicle. And then, in fact, as you hear from the owner of that pickup truck, his vehicle was stolen, I think, on September 30th of last year from out in front of the house. So now they have that vehicle, but that vehicle has a very identifiable plate. Poco, it was the company name. Poco is part of the plate. So to disguise it another level, a DTE license plate gets stolen to put onto that vehicle. Poco is replaced for an actual DTE plate. That's the level of disguise that is going through, and that disguise is to get in the house and to get out of the house without getting caught. Now, you've seen the text as it progresses. The defendant is coming up with ways to make that truck look like a DTE vehicle. He is going in person on video to order that DTE nameplate for the sides of the truck. As he's doing that, he's sending those samples, his proofs of what it's going to look like to the co-defendant. And as he does that, he's also on video picking it up. The poor guy who owns the sign company was so afraid that he was somehow involved with the homicide, he immediately calls the sheriff's department after it takes place. So then you hear what else they're doing to try to disguise their appearance. They're going to Home Depot, they're going to Lowe's, they're getting other type of work materials that would look like they're DTE people to disguise themselves. You see Zuazo is communicating with one of his buddies who actually worked with DTE and had DTE equipment and helmets to get that as part of their plan. And then they're ordering at Home Depot duct tape. And after they get the duct tape, you'll hear that the plan is in place now. They're basically ready to go. But there's something that they weren't able to prepare for and buy at Home Depot or Lowe's. Something they needed to accomplish that. And that something was the will to do whatever was necessary to get into that house and to commit that larceny. That will to do that comes from in here. That you can't buy. So equipped with all the things that they have pre-planned, they head to Rochester Hills on October 10th, late. They have an entire long drive to get to Rochester Hills. They don't turn around, they don't leave, they don't decide not to do it. They show up at 10 o'clock. And when they go to that door, which has Ring cameras, and I think you'll remember in passing the deputy within seconds of getting there, before he's even been inside, he says there's Ring cameras all around this house. They're that visible. They're not secret Ring cameras. So you're on Ring camera. And as they get to this house, who's leading the way to the door? This defendant. He's at the door first. He's the one who's making contact. He's the one who's the knock on the door. And Mrs. Murray's alerted on her phone because everything bounces to the phone from Ring camera. And Mr. Murray is downstairs while she's already upstairs getting ready for bed. And as he goes to the door and answers the door, and there's the defendant with the co-defendant behind him, dressed like DTE, trying to disguise their face with the mask that they're wearing. He said, "We're here to check the gas leak. We need to get in the house." And Mrs. Murray, who's hearing this from upstairs, says, "Isn't it a little late for a gas check?" And the defendant continues talking to Mr. Murray. And she yells down, "Sam, do you have your gun on you?" And she said it loud enough with the intent for the folks at the door to hear it. And we know that her husband did have a gun and that he would carry that gun. So as that's being said, her husband isn't letting him in at 10 o'clock. There's no smell of gas in the house. So, no, I'm not letting you in. And the defendant has a clipboard to make it look like they're there to get permission and consent. It's even part of their text messages about making it look like there's a consent form when you go to the door. More ways to trick the Murrays into letting them in. It wasn't happening on the 10th. The defendant says, "We'll be back tomorrow." And he leaves. And that door shuts. And we've talked about before in jury selection unanswered questions. And there's unanswered questions about why did they leave that night on the 10th. And those questions don't have to do with the elements to prove about what happened on the 11th. But, when you're opening that door and you've heard Mr. Murray is not a small person, 6 foot tall, nearly 300 pounds. And then you hear it accompanied by Mrs. Murray saying, "Do you have your gun on you?" So now you have the defendant who's the first one closest to Mr. Murray. So in those moments, was there a calculation that he was not going to be able to get to Mr. Murray before Mr. Murray could back up and pull his weapon? Was there a calculation that if there was going to be a struggle, it was going to take a while? And you also heard that Mrs. Murray was at the top of the stairs. And I don't know what calculation could have happened if they had gone in at that moment. But There was no way they were getting up those stairs to Mrs. Murray on the second floor before she dialed 911. No way. There wasn't any way to accomplish that. So they leave and they drive back, a long drive back. And in that drive back, do they decide, we're not doing this again tomorrow? This is a mistake? Do they decide that we're not gonna go against the Ring cameras? We're not gonna go against Mr. Murray? We're not gonna go against the potential that he's armed? We're not gonna go against the Oakland County Sheriff's Department if they're called? We're not gonna go against the law. Do they decide that this is a bad decision? No. Instead, they're already texting that night between the two of them about the plan for tomorrow. What time am I going to get picked up at? And they also decide that whatever they brought on that first trip on the 10th, it wasn't enough. The plan had changed after seeing Mr. Murray at the door. Now they wanted the extra long zip ties. And those are the extra long zip ties you see, unfortunately, in that gruesome scene in the basement. Those are the extra long zip ties that you see were put into a position where it could be used like a handcuffs left on the floor, because they never got that far with that set of zip ties. And at 9:30 the next morning, the defendant is back to picking up the co-defendant and headed to Lowe's. And they're headed to Lowe's to make that purchase of those zip ties and take another run. They're not going to be thwarted from getting into that house. Nothing is going to stop them from going through that house looking for riches that don't exist. And they show up that next morning at about 11. And they show up in that DTE vehicle. And you'll remember Mrs. Nyhouse, who's walking her dogs, says, I noticed a sound, and I wasn't really, it's just a weird vehicle sound. And, I look over and I finally see this slow rolling vehicle, but it's marked with DTE. And at that point, I wasn't concerned anymore, because I figured they were there just going through the neighborhood. Yes, they were successful. They had tricked the neighbor into thinking it was a legitimate DTE vehicle. So now they get out of the vehicle and go up to the Murray's home to trick them to get into the house. And unfortunately, this time it worked. And you'll hear how, once again, Hernandez is leading the way through that door. And you heard again how they're saying they're there for a gas leak, which doesn't exist. And then you hear that once they get into the house, they want to get down into the basement. For some reason, they think the safe is down in the basement. So once inside the house, as you hear, Mr. Murray goes down first, the co-defendant goes down second, and then the defendant is following behind. And Mrs. Murray doesn't think anything is off at this point. She goes back to the kitchen to continue making breakfast. She says she's there 10 or 15 minutes, doesn't hear anything from downstairs, doesn't hear a commotion, doesn't hear a scream, doesn't hear anything. And as that 15 minutes goes by, she's finished with her breakfast making, and up comes Defendant Hernandez first. And Defendant Hernandez comes up from downstairs. They're close to each other, and he starts immediately, where's the safe? Where's the money? Where's the jewels? Now, it's instantly apparent that this is no longer a DTE visit. And she starts saying, we don't have much cash. I got $300 that's in my purse. Where's the safe? We don't have a safe. There's no safe here. Where's the jewels? There's no valuable jewelry here. He continues asking about that. And within seconds, up comes Zuazo, as she said. There was a very brief time period difference, not very long at all. And as she's asked about where's my husband, Zuazo shows up. And she says, where's my husband? And he says, well, he's sleeping. And then she sees the blood on his front of his shirt that he's wearing. And she immediately starts screaming. And what does the defendant do? He hauls off 6'5", 450 pounds, and punches her on the left side of the face. You saw her injuries that were later photographed. That's a real hit. Are you going to keep screaming? No. So then what does he do? He starts to duct tape her. The larceny is still going. The larceny isn't over. They got a gun off of Mr. Murray down in the basement. They got his gun, we know that. And defendant Zuazo goes upstairs and starts ransacking because they're still looking for things to steal. The defendant is going through her purse, taking cell phones, taking cash, going through kitchen drawers to find those things. Larceny's not over. He doesn't go running out of the door. Zuazo doesn't go running out of the door saying, this is over, this is ridiculous. No, they're continuing with the plan. And that plan was, as you saw in the text messages, the defendant wants to buy a house with what they expect to get from this larceny. They want to buy a house. They don't want to work hard and save up for it and do all the things that you have to do to be able to buy a house. They want to go in there and steal for a house. They want to go in there, and if it takes ending Mr. Murray's life to get that money for a house, so be it. And as you hear, she's getting duct taped up by the defendant. Zuazo comes down with the drawer of jewelry. And then what? You think that it's over then? No. They both want to put her in a closet before they leave. Let's put her in the closet. And they try to put her in the closet. And they're not able to put her in the closet because of the way she's taped up. So she's left there without her cell phone, and they leave. And as soon as they leave, they continue doing what they want to do from the beginning, which is to get away with it. So they take that truck down to Detroit, because that's direct evidence. They're in that truck. There's probably going to be DNA left in that truck, and they set it ablaze. That truck goes on fire. And then you see the vehicle being followed by the defendant's wife within minutes to where the truck is found blown up within minutes. Because he's still trying to get away with the larceny. So as the investigation continued, the sheriff's department very quickly, very wisely put out that video to the media. And that video went out on the media quickly, and the defendant was quickly identified as being one of the two people in it. Physically distinctive. And as they do that, they start figuring out what vehicles are registered to him, where does he live, does he have any other residences, and they figure out his Jeep, they figure out the Texas residence, they figure out he's gone from where he was staying up here with his mother-in-law. That mother-in-law who identifies him as being the other person in, one, the Ring camera, and then also identifies him as being on that Lowe's video. She did that in front of you. She'd never had the opportunity to see the Lowe's video before. She identifies both defendants an hour before this. At that point in time, they're stopped in Louisiana. Louisiana takes everything into evidence, and at that point, you hear when it's brought back all the things of significance that is in there from Louisiana. You find the size 13 shoes, boots, that belong to him, and you see 2 pairs of 13 sneakers that weren't connected to this. So he has 3 pairs of 13, and on the bottom of those 13s, you'll see blood was discovered, and then you'll see that he's collected a lot more of the evidence that didn't even belong to him. He has Zuazo's boots. He's probably tasked with destroying some of the evidence, and he's keeping that. Is he keeping that to negotiate something down the road? Who knows? But he kept it. He still has the DT clipboard. He still has the DT sign. He still has the POCO license plate. He has all these items with him, including the stolen jewelry. So, what you see down in the basement, which is absolutely brutal, what you see down in the basement is, and I think very obvious, that Mr. Murray was putting up a struggle. Okay? The only blood that's ever found is Mr. Murray's blood. There's no blood of the defendants. There's DNA of the defendants, but it's not DNA from blood. But he's struggling. And when he's struggling, no matter how big or small either the defendants are, when you're struggling, they had to bind his hands. They had to bind his mouth. And they bound the hands with both duct tape and those zip ties. And why it's important, and I think it shows, not just because the doctor said the blood is in his lungs, which means he's bleeding, so there's already been that physical altercation, and he's bleeding and inhaling it. That doesn't happen if you're already dead. You don't breathe and inhale once you're dead. And at that point in time, you see very clearly in the photos, that Rolex is bound underneath those zip ties. It's bound in a way that even the ME said no, that it was secured under those zip ties. Because Hernandez likes the Rolexes. We know that, coincidentally. If he could easily have gotten that Rolex off, that would have been the most expensive item to take from that scene. But he wasn't able to do it because there was a struggle going on. You heard the multiple blows that Mr. Murray sustained in multiple areas of his head, of his face, consistent with the butt of a gun that was never found, that was taken out of there. The money was never recovered. The cell phones were never recovered. But what was recovered was the defendant's t-shirt, XL6 size, that has the victim's blood on it. What was recovered was the duct tape rolls in the basement that has both defendants' DNA on it. And the other thing that you can't escape, defense is going to have a closing. I don't know what they're going to say, but you can't escape saying he's not part of that bloody scene. He wasn't upstairs when that happened, because if he's upstairs when that demolishing of Mr. Murray occurs, there isn't going to be Mr. Murray's blood on his t-shirt. There isn't going to be Mr. Murray's DNA on the bottom of his shoes. And you also heard from the crime scene that they took kind of a special type of thing to uncover any type of blood evidence that was down there. This is admitted into evidence. I'll show you what's been marked as and introduced into evidence as exhibits 3K, 3O, and 3M. The black 13 Nikes from both sides. But look at that distinctive pattern on the bottom. That is unique. That's unique to the eye. Now there's blood found on these shoes, and that's the victim's blood. But to say he's not down there when this occurred, exhibit 2AA and 2BB. Look at that pattern that's left on the bottom of that floor. The unique ridge line on the side of those shoes on the bottom. I'll have an opportunity to address you after Ms. Lofton is finished, but I appreciate your attention.
Go ahead, Solomon. Thank you. Good afternoon. It is quite clear that you have been an attentive jury and you've paid attention to all of the evidence and taken notes when you felt it was appropriate. So I'm not going to stand up here and go over every single thing that we have heard in these last 3 long days. But it is important to go over a number of things that you heard and some things that you didn't hear. Since it's the prosecutor's burden, as he just mentioned, he gets to speak to you twice. So I apologize in advance for my long-windedness, as I only get to speak to you once. We have told you many times that you, as juror members, are here to piece together what happened on October 11th, 2024 in the city of Rochester Hills. As you were told in voir dire, the prosecutor must prove each and every element beyond a reasonable doubt. The prosecutor carries a very heavy burden. This doubt can be created by the evidence presented, but also by the lack of evidence that the prosecutor brought forth. Now, we saw a Ring camera video from October 10th. Clearly shows that in the evening, 2 individuals came to the Murray's home and asked to come inside to look for a gas leak. They were turned away. We also know from Ring camera footage that the following day, in the morning at 11:22, the same individuals returned to the home, and this time they were let in. We know from the garage Ring footage that these 2 individuals left at 11:41. So we are talking about 19 minutes. We also know that the 911 call was placed at 11:47 a.m., within 5 minutes of these 2 individuals leaving the home. We heard from Deputy Copeland and actually got to watch his body camera. He was the first responder. You can tell from that body camera that he responded and got out of his car at 11:54 a.m. Officers do not enter that basement until 12:08 p.m. He, in fact, does not check for a pulse until 12:13 after saying, "I know it's silly, but what the hell? I will check for a pulse." The paramedics arrived even minutes after that. He testified, and you could hear from the comments that were being made on his body-worn camera, that he believed that Mr. Murray was shot in the head, which is usually an untreatable situation. We know from Dr. Shauna Bryan, the medical examiner, that Mr. Murray was actually still alive after the assault occurred because blood was found in his lungs, and also based on the fact that there was a large amount of blood found on the floor around him. And as the doctor explained, his heart was still pumping. It was 30 minutes from the 911 call until someone attempted to render aid. Another important detail from Deputy Copeland were his comments that he found blood on the wall and the handrail leading to the basement. This blood swipe is very similar to the one that we heard and saw that was located upstairs near the bedroom. And who did we find out was the only person that went upstairs? Mr. Zuazo. We heard from Valerie Myra, the forensic lab investigator. She was responsible for taking the photos and assisting in the processing of the scene. She told you that when collecting evidence, you never just toss it into one bag because it ruins the integrity of the DNA. She also said that when you have wet items, you put them in paper bags. You don't put them in plastic bags. She took all of the pictures of the scene and then also did some fingerprint analysis back at the lab. Now, she did photograph that swipe, that blood swipe upstairs. She was not directed to it and didn't see it or photograph the one down by the basement. We heard from another forensic lab investigator, Sierra Ramirez. She detailed her impressive academic achievements to be able to hold the position that she does. Now, she was in charge that day on collecting the evidence at the scene and then processing a number of the items for DNA. She explained that when you're collecting evidence, you need to wear gloves and wear a mask to prevent any type of DNA transfer or degradation of the DNA. You saw her not even wanting to open the package that Mr. Petrofessa handed her without gloves and a mask. She said it is very important when collecting evidence that you put everything in separate bags. She also described that if something has a biological substance on it, like blood, and that item is put next to something that is dry, DNA can transfer. Was Mr. Hernandez's DNA on the rolls of duct tape? Yes. We know he purchased the rolls of duct tape. Mr. Hernandez's DNA was also found on a number of items that were found in the back of his car after he handled them and packed them into his car. We also know that he packed all of the items that Mr. Zuazo was wearing in a black bag, which was found in his trunk. Now, we heard some testimony from Thomas Keelan. He was the individual that worked for POCO, and he testified that his truck was stolen on September 29th. Now, like we discussed in voir dire, even if you believe that Mr. Hernandez was responsible for stealing the car, he's not charged with that. The fact that the truck was stolen does not satisfy any of the elements of the charges that he is on trial for. We also saw and heard from multiple witnesses saying that the truck was burnt. It was driven to Detroit that same day and burnt out. Again, Mr. Hernandez is not charged with anything related to the damaged vehicle. The burning of the truck does not satisfy any of the elements of what you are here to decide. We heard from Brian Broad, that was the former boss of Mr. Zuazo. We heard that he identified him from a video that was played on the news and the social media, and he immediately called the police. He also testified that Mr. Zuazo was let go due to poor performance and not following the rules, and that when he was fired, he decided to call his boss and tell him he was going to kill him. We heard from Deputy McCoy and the detective Casey Jones from Louisiana that Mr. Hernandez had an address in Katy, Texas, and that a be on the lookout was put out in the United States, and he was pulled over in Louisiana in a white Jeep. You heard that when he was pulled over, he complied with everything that was asked of him, and he pulled over immediately. We heard from Hannah Hussein. She's a family member of the Murrays and has been a store employee at that pawn shop for 20 years. She told you that in 22 and 23, Mr. Hernandez pawned items at the store that was owned by Mr. Murray. She described that in January of 2024, someone came in and redeemed the items that Mr. Hernandez had pawned. She couldn't say who that person was, but someone came in. She also told you a story that had never been previously told to police or written in a statement. Even though she agreed with me, it was an important detail. She told you at some point, which she does not know when, she remembers Mr. Hernandez entered the store when she was working and asked about a Rolex, and then asked to talk to the owner, Mr. Murray. She has worked at that store for 20 years and testified that on some days she sees 50 people. In reviewing her testimony in the jury room, I ask that you review the judge's instruction on credibility. If we are to believe that that happened and Mr. Hernandez had an interest in Rolex watches, I understand Mr. Petrofess's explanation of why that Rolex would not have been left on Mr. Murray's wrist if Mr. Hernandez was the one that was doing the assault. Does the fact that Mr. Hernandez went into the pawn shop owned by Mr. Murray in October of 2023 prove any of the required elements? I say no. Even if you believe that he went into the store in January of 24 to redeem his items, it does not prove any elements. There is no evidence to show that he had somehow been following Mr. Murray for over a year. Now, we heard from Linda Murray, and I think that Mrs. Murray did the absolute best job she could testifying. Definitely the worst day of her life. Now, she told you that on the night of October 10th, she yelled down to her husband asking if he had his gun on him. If we are to believe that she said that loud enough for Mr. Hernandez to hear, does it make sense that they would come back the next day with no weapon? Especially not if the plan was to injure Mr. Murray. Now, she told you that she never saw any type of weapon from either Mr. Hernandez or Mr. Zuazo. Another interesting detail she mentioned was that Mr. Zuazo went downstairs with a mask. He had it on his face. But when he came back up, he didn't have a mask on. So whatever happened in that basement with Mr. Zuazo, it caused him to lose his mask. Not Mr. Hernandez. He still had his mask on. Would a man that is 450 pounds be able to do the assault that we saw the results of and walk back upstairs with that same respirator mask on? I argue no. The most important part of her testimony in relation to Mr. Hernandez was the proximity in which Mr. Hernandez was to her for about 10 minutes of the time that he was in that home. All of the close interactions that she described happened after Mr. Hernandez had come up from the basement. She told you that he used his arm to grab her and take her to the kitchen. She told you that she watched his hands as he took off her watch, as he took her phone, as he went through her purse, as he went through the drawers in the kitchen. She was within inches of him as she watched his hands put duct tape on her wrists and on her ankles. She never saw one drop of blood on him. Not on his mask, not on his hands, not on his vest. No blood was smeared or swiped on her when he did all of those things that required him to make physical contact with her. interview of Mr. Hernandez, but also the detective who testified that he talked to Mrs. Murray pretty consistently for over a week and compiled his understanding from the interviews with her. I actually read from his report, and he agreed with all of the statements in it. He stated that Mrs. Murray had told him that Mr. Hernandez came up from the basement and began to ask for money, jewelry, goes through her purse, takes her phone. That there was a period of time where this happened before Mr. Zuazo came upstairs. Now, once Mr. Zuazo comes upstairs, Mrs. Murray sees the blood on him and screams. This timeline fits exactly with what Mr. Hernandez says in his interview. And obviously at the time of his interview, he had no idea what had been reported to the police. But he tells the detective, everything was fine until Mr. Zuazo comes upstairs and he has blood on him. Now, we saw a lot of text messages today that Mr. Hernandez exchanged with his wife and with Mr. Zuazo. In all of those hundreds of text messages, nothing about a gun, nothing about a weapon, nothing about killing. Now, conversations about an elaborate larceny? Absolutely. Conversations about taking things that weren't his? Yep. But Mr. Hernandez does not have a charge that you are here to decide that is alone called larceny or home invasion. Now, we heard from the medical examiner, Dr. Shauna Bryan, and she told you that Mr. Murray did not die of a gunshot wound, which was previously thought, but actually, he died after being beaten in the head and the neck. She told you that blunt force injuries could have been from an object, or a fist, or some of them could have even been from a fall. That while the injuries were severe, they could have been done by someone that was just 150 pounds. She also testified it takes 6 pounds of force, or as she described, the weight of a human head, to compress the neck to stop breathing. This definitely could have been done by one person. Now, after his arrest, Mr. Hernandez did not have to talk to the police. As you know, Mr. Zuazo did not. He could have remained silent, but he didn't, because he wanted the deputies to know that he was not part of the beating of Mr. Murray, and he wanted to tell them that. Now, it's usually not appropriate to talk about someone's size, but because it's been such a topic of conversation here, let's talk about it. Remember the video of the interview in Louisiana. At that time, my client was booked into the jail at 450 pounds. As you could tell from those Lowe's videos, he had some trouble walking, and if you watch at the end of that interview, he could barely get up from the seat. Now, remember back to the photos of where Mr. Murray was found. That space is extremely small. I argue that there is no way that Mr. Hernandez could have been the one attacking Mr. Murray. One, I don't think he's physically able to, and keep his mask on. And two, there wasn't room. Now, Mr. Hernandez was open and honest about the fact that a truck was stolen, signs were made, outfits were purchased, forms were printed out, badges were made, clipboards, duct tape, zip ties. They bought hard hats. We saw them at Lowe's and Home Depot. All in elaborate preparation of a larceny, not a murder. You did not see them at a gun store. You did not see them buying weapons of any sort. That is because it is clear from the evidence and clear from what Mr. Hernandez kept saying in his interview. It was not supposed to happen. Mr. Murray was not supposed to die. For that whole hour, Carlos kept the same tone, the same mood, until he was asked one question. If you killed the husband, why would you leave the wife alive? It was not supposed to happen. There was never a plan to kill Mr. Murray. If there was a plan to kill, why would you need to bind someone with duct tape? If someone is dead, they don't need to be bound. Think about that. They chose to walk in with tape instead of a weapon. Does tape show intention to kill? I argue no. Dr. Bryan told you that the duct tape on his hands and feet and mouth did not kill him. If there was a plan to kill, once the gun was removed from Mr. Murray by, I believe, Mr. Zuazo, why wasn't he shot? Why then wasn't Mrs. Murray shot? Now let's talk about the mention of an insurance policy in the interview and the correlation to the black bag found in Mr. Hernandez's Jeep. In that black bag, we were told Mr. Zuazo's boots, gloves, hat, and 2 masks were located. DNA clearly shows that those items were his, and they match what he wore on the Ring camera. Now, how did Mr. Murray's DNA end up on the large white t-shirt and the shoes of Mr. Hernandez? Well, unfortunately, Mr. Hernandez does not have the years of training regarding biological substances like the evidence technicians. Mr. Hernandez's own clothing was found in the same plastic bag as the bloody items from Mr. Zuazo. We learned about DNA transfer and degradation. If Mr. Hernandez had blood on him, Mrs. Murray would have seen it. I asked you in voir dire if you understood that you were not here to decide if Carlos was a nice guy, if you'd like to have him as a neighbor, or if you'd like him to have him date your daughter. Do you remember that question? And why is that important? Because again, even if you don't like him, none of the elements are satisfied by that fact alone. You may not like any of the actions that Mr. Hernandez took leading up to October 10th, on October 10th, or October 11th. The fact that he did some bad things does not then automatically mean that he committed the acts for which he is charged. Now I want to talk about the actual charges now. So we know the first count is first-degree felony murder. To prove this charge, the prosecutor must prove each and every one of the following elements. First, Mr. Hernandez caused the death of Hussein Murray, that he died as a result of neck compression and blunt force trauma. Second, Mr. Hernandez had one of the 3 states of mind. He intended to kill, he intended to do great bodily harm, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, that when he did the act that caused the death of Mr. Murray, that Mr. Hernandez was committing or attempting to commit or helping someone else commit the crime of larceny. And as we all know, after the end of 3 days, a larceny is a taking of property with intent to permanently deprive the owner without consent. Now, did the prosecutor prove to you beyond a reasonable doubt that it was Mr. Hernandez that caused the death of Mr. Murray? I argue no. The prosecutor now gets 2 bites to this apple here. They are either arguing that yes, it was Mr. Hernandez who actually did the beating death of Mr. Murray, or if you don't believe that, then he is still guilty under aiding and abetting. This instruction is so important and actually very helpful to you when you go back in that jury room, so I want to go over it. The judge is going to tell you to prove the theory of aiding and abetting. The prosecutor must prove all of the following elements beyond a reasonable doubt. First, that the alleged crime, which is felony murder, was actually committed either by Mr. Hernandez or someone else. Second, that before or during the crime, the defendant did something to assist in the commission of the crime. And third, which is the absolutely most important element. Third, at the time, Mr. Hernandez must have intended the commission of felony murder, or must have known that the other person intended its commission, or that the crime alleged was a natural and probable consequence of the commission of the crime intended. Was murder a natural and probable consequence of the commission of larceny? I argue absolutely not. And because of that, you have to find Mr. Hernandez not guilty of felony murder. These 2 individuals did not bring a weapon. They walked in the home with fake DTE equipment and duct tape and zip ties. Death was not the natural and probable consequence of those actions. It is clear that Mr. Hernandez went into that house thinking he could make some fast cash and get a house. There has been absolutely no evidence that Mr. Hernandez went there with the intention to kill anyone in that home, and because of that, I argue felony murder was not proven. Now, Mr. Hernandez is also charged with 2 counts of unlawful imprisonment. As we discussed in openings in voir dire, there's 1 count as to Mr. Murray, 1 count as to Mrs. Murray. The elements are the same. For count 2, unlawful imprisonment against Mr. Murray, I do believe that the prosecutor has prove the elements of this charge under the aiding and abetting theory we just went over. Mr. Hernandez went into the house after purchasing duct tape and zip ties that he shared with Mr. Zuazo. I believe the evidence then shows Mr. Zuazo used those items to restrain Mr. Murray. The binding of Mr. Murray was a natural and probable consequence of him walking in there with that tape. I believe the prosecutor proved that to you. As to count 3, unlawful imprisonment against Mrs. Murray, I do believe that the prosecutor has proved the elements of this charge. The testimony of Mrs. Murray indicates that it was Mr. Hernandez who used duct tape on her wrists and ankles prior to leaving the home. The verdict form will not say guilty or innocent. The verdict form will say guilty or not guilty. And by voting not guilty, you are voting not proven, that the prosecutor has not proven his high burden. I ask on behalf of my client, Carlos Hernandez, that you return a verdict that is consistent with the law, consistent with justice, and a verdict that is supported by all of the facts and evidence that you have heard in the last 3 days. And that would be a verdict of not guilty as to count 1 and guilty as to count 2 and 3. Thank you very much.
Thank you, Ms. Laughlin. Any rebuttal here?
Briefly, Judge. Again, defense counsel starts off with talking about a plan to kill when they arrived at the house. That is not what felony murder is. That's first-degree premeditated murder. That's not how you're going to be instructed regarding the elements to be proven in this case. I would also say that there's a couple definitions that I maybe take issue with or need to be amended after this case has gone through. The first one would be forthcoming in describing the defendant's statement to the Oakland County Sheriff's detectives. What I heard, and I think it's only got little worth, but I don't think it was very forthcoming when he was talking to the detectives. If you recall, which I thought were the highlights of it, defendant says, when he's supposed to be forthcoming with the detectives, he says, "I never said I was there the second day. I never said I was there the second day when all the bad stuff happened." At that point, he's trying to portray himself as only being there on the 10th, where nothing really bad happened. That was forthcoming statement number 1. Then you remember he was asked about Mr. Murray fighting back. There was no response to that question at all. Silence. He doesn't want to talk about what happened in the basement with Mr. Murray. And then, shocking, he says, when asked about hitting Mrs. Murray, he says, I don't recall hitting Mrs. Murray. That was another one of his forthcoming statements that he made to the police officers. And the final term that I would change is that this was an insurance policy for him, because what he had in that black bag was anything but an insurance policy for him. Now, there was a statement about his mask not being in place and there should be more blood on the defendant. More blood, we need more blood. Well, you hear from the first deputies on scene that they're reporting as a gunshot wound. That's how much blood there is at that scene, that they believed it was a gunshot wound. That's how much blood was there at the scene. We need more blood? Okay, well, the facts give you more blood. As you heard the testimony, you have the exhibits for the defendant, C and D, that are moved into evidence, in the stuff that's found with them. Face covering N95, red stain on the exterior. Defendant Hernandez on the interior. Both victims on the exterior of that. Defense wants more blood? Okay, well, 7E, white t-shirt, which is into evidence before you. Swab both the inside and the outside. Defendant Hernandez on that 6XL t-shirt is in the interior. Victim Sam Murray is in the exterior of that exhibit. More blood still? We've already talked about it. Those black Nikes. But not only is there the blood of the victim on the outside of those shoes, the blood of the victim and his DNA is inside the shoe also. That's how intimately connected the defendant is with that bloody scene. And then finally, as we also discussed, 7G, the black gloves that were found on the defendant when they were stopped. Exterior victim of the victim. Interior is defendant Hernandez. Also interior is victim Linda Murray. So, I guess the best response I can have about trying to have it both ways, I believe that was said at some point. At no point have I ever theorized that only one of the defendants obliterated Mr. Murray in that basement. I don't believe only one of those defendants had contact with him when this was occurring. I believe both defendants had contact with him down in that basement when he put up that struggle, because they have to disarm him. And disarming him first is probably one of the main priorities. But then he's attacked from the back and his head is bleeding. Now, I tried to think about, a response to that, but growing up, I have a brother, he's 4 years younger than myself, okay? So growing up, for a long time, I was the older brother, and when we roughhouse and play around and wrestle and stuff like that, I could get both of his arms, his wrists in one hand and hold him down with one hand and a second hand free to tickle him. I don't know what you want to say, but you could hold both arms in one hand. When he got older, I couldn't do that anymore. And if we were going to struggle, it would take a hand in each hand to do it. Now, Mr. Murray is a big guy. Mr. Murray is struggling. There is no way that you're holding down Mr. Murray as he's struggling with one person and then binding him in that position. There is no way one hand is holding him with one hand and tying him with duct tape with the other, with zip ties. Impossible. Both of those guys were doing that down in the basement. They have the blood of the victim on it to prove it. You don't get blood on you like that if you're upstairs with Mrs. Murray asking about where the safe is. I believe the evidence has clearly shown that the defendant is guilty of charged of the murder and of the other 2 counts. I appreciate your time and attention. Thank you.
Okay, so now we're going to, actually that's it. We're not going to listen to jury instructions because this is just about, what do you call it? This is just about the closing arguments and then now the verdict. So the whole point why we are doing this is if you guys were with us on Friday or if you weren't with us, here's why. We were on this one channel and it went to verdict. We were in verdict watch. And then we just got that spinning thing. So then we were on another channel and we saw it came in, but it was actually on their website. So we went there and they announced it, they announced the verdict. So it just seemed, I don't know, it seemed like I just wanted to have, for posterity's sake, I just want to get the closing arguments and then the verdict in one nice clean stream. And then we also have a press conference we're gonna show as well. So let's get to that. Meaning the verdict. So now the verdict is going to come in. We're going to actually see the full verdict versus just, juror number 2.
Please support John Patrick.
Is this your verdict? So anyway, so here we go.
Can you please support John Patrick Fest and Andrew McGarrett on behalf of the people?
Good afternoon, Your Honor. Michael McCarthy, T30169, appearing on behalf of and with Joshua Zuazo. Mr. Zuazo is standing to my left at the table.
All right, sir, tell me your name. Okay, all right, just by way of background to place on the record, the jury was sent out to deliberate, what would we say, was it around 4 p.m. We got note 1 came in on behalf of Mr. Zuazo at 4:15 p.m. and it said, "We have reached a verdict." That note came in when we were in the other proceeding. The court was aware that a verdict had come in and did not address the jury at all. Where's the note that they just sent? The note where they talked about, we just need to know what's going to happen. Do I have that? Oh, is it in its own envelope? Oh, here it is. Okay, yeah. So this note comes in just now at 5:53, and it says, "Is it possible to get an update on the process? We're not sure what to expect, and any info would be appreciated." All this has been communicated to all the attorneys. They're aware of it. As soon as I got the notes, I just wanted to place that on the record that those were the only two notes written on behalf of defendant Zuazo. So we're going to accept our verdict now. Let's bring our jury in.
You guys want to hear that again? All right, let's hear that again.
Please. In, just now at 5:53, and it says, "Is it possible to get an up?" And did not address the jury at all. Where's the note that 15 p.m. we say it was around 4 p.m. We got jury was sent out to deliberate. What would we say was around 4 p.m. We got note 1 came in on behalf of Mr. Zuazo at 4:15 p.m. and it said, "We have reached a verdict." That note came in when we were in the other proceeding. The court was aware that a verdict had come in and did not address the jury at all.
So yeah, 15 minutes. Now I have in my notes they started at 3:11, so we shouldn't be behind. We should be the same time zone because they're on the east. They're Detroit, Pontiac. They're east, right? They're not central. They're east. So I have 3:11. It started. She's saying 4 o'clock. Well, in any event, 15 minutes. So wow.
Where's the note that they just sent? The note where they talked about, we just need to know what's going to happen. Do I have that? Oh, is it in its own envelope? Oh, here it is. Okay, yeah. So this note comes in just now at 5:53, and it says, "Is it possible to get an update on the process? We're not sure what to expect, and any info would be appreciated." All this has been communicated to all the attorneys. They're aware of it. As soon as I got the notes, I just wanted to place that on the record that those were the only two notes written on behalf of defendant Zuazo. So we're going to accept our verdict now. Let's bring our jury in.
3:11 they started. 3:11.
Ladies and gentlemen of the jury, please be seated. All right, so we are in receipt of your note that you have reached a verdict. Have you chosen a foreperson?
Yes.
All right, Mr. Foreperson, did you bring in that verdict with you? Okay, if I can just take a look at it, and I just want to review it to make sure that it is signed and dated, and then I'm going to give it back to you, and you can let us know what your verdict is. Okay, all right, I'm going to send this back to you. Just read as to each count what you found, please.
Count 1, first-degree felony murder. Guilty as charged of first-degree felony murder. Count 2, unlawful imprisonment. Guilty as charged. Count 3, unlawful imprisonment. Guilty as charged.
All right, thank you, Mr. Foreperson. We'll collect that verdict form from you, and you could be seated. Would anyone like the jurors polled?
Your Honor, I would make that request.
Okay. All right, juror in seat 1, sir, is that and was that your verdict?
Yes.
Juror in seat 2, is that and was that your verdict?
Yes.
Juror in seat 3, is that and was that your verdict?
Yes.
Juror in seat 4, is that and was that your verdict?
Yes.
Juror in seat 5, is that and was that your verdict?
Yes.
Juror in seat 6, is that and was that your verdict?
Yes.
Juror in seat 7, is that and was that your verdict?
Yes.
Juror in seat 8, is that and was that your verdict?
Yes.
Juror in seat 10, is that and was that your verdict?
Yes.
Juror in seat 11, is that and was that your verdict?
Yes.
Juror in seat 12, is that and was that your verdict?
Yes.
And juror in seat 13, is that and was that your verdict?
Yes.
All right, ladies and gentlemen, on behalf of myself, my staff, and the attorneys, we sincerely appreciate the time and service that you have put in this week. I know it's been a long day and a long week. If you can wait back in that jury room for me, I would like to come back and just say hello and chat with you. I'm not going to be able to get right back there, though, so if you have to leave, I do understand. But if you can wait, that would be great. I'd like to say hello. Thank you.
All rise for the jury.
All right, and bond is already denied here, is that right?
Yes.
All right, so bond remains denied, and we will come back here for sentencing on.
December 9th at 1 o'clock.
All right, December 9 at 1 o'clock. I'll see
Judge,
everyone.
the only thing, and I know Mr. McCarthy is aware of, just at the time of sentencing, we need to address the habitual offender notice too for the record.
Okay, we'll do it then.
Very well.
We're all set. Now let's call it. Ms. Lofton, we've called for your client if you want to come up.
Would you like us to stay in the same seats that we have been in?
Yeah.
Mr. McCarthy, did you get the referral form?
Yeah, I do.
You want to email it to me?
you.
Great, thank you.
I'll get it to you.
Okay.
I have to give it to you.
Sure.
Oh, are we ready? Okay, let's call the case.
Calling People versus Carlos Hernandez, case number 2024-291-945-FC.
John Petrofessa and Andrew Laguerre on behalf of the people.
Paula Michelle Lawton on behalf and with Mr. Carlos Hernandez.
All right, tell me your name.
Carlos Hernandez.
Okay, all right, so by way of background, the jury was sent out around 5 p.m. I got a note number 1 at 5:21 p.m. It says, Jury B is requesting Mr. Hernandez's t-shirt. That was submitted as evidence, as well as the photos of the back of the Nike shoes, the photos of the shoe prints at the scene, as well as the M95 mask with Mr. Hernandez's DNA on it, as well as the crime scene photos of Mr. Murray in the basement. The court discussed this off the record with the counsel, and those items were then put together and sent back to the jury. And at 5:58 p.m., the next note came in and it says, Jury B has reached a verdict and we will bring them in to receive same.
So they were 5 o'clock. They started 5:58. They reached the verdict.
All rise for the jury.
Welcome back, ladies and gentlemen. Please be seated. Okay, so we did receive a note that says that you have reached a verdict. Did you choose a foreperson? All right, Mr. Foreperson, I'm going to have you read us that verdict, but first I just want to take a quick look at it just to make sure it's signed and dated. Thank you. Okay, I'm going to send this back to you, and if you could just read what your verdicts are as to each count.
Should we stand?
Sure.
For count 1, first-degree felony murder, the jury finds defendant Hernandez guilty as charged of first-degree felony murder. Count 2, unlawful imprisonment, the jury finds defendant Hernandez guilty as charged of unlawful imprisonment. Count 3, unlawful imprisonment, the jury finds defendant Hernandez guilty as charged with unlawful imprisonment.
Okay, all right, thank you. We're gonna get that verdict form back from you. Would anyone like the jurors polled?
Yes.
All right, juror in seat 1, is that and was that your verdict? Yes, I have to hear, we're recording, yes? Yes. Juror in seat 2, is that and was that your verdict?
Yes.
Juror in seat 3, is that and was that your verdict?
Yes.
Juror in seat 4, is that and was that your verdict?
Yes.
Juror in seat 6, is that and was that your verdict?
Yes.
Juror in seat 7, is that and was that your verdict?
Yes.
Juror in seat 9, is that and was that your verdict?
Yes.
Juror in seat 10, is that and was that your verdict?
Yes.
Juror in seat 11, is that and was that your verdict?
Yes.
Juror in seat 12, is that and was that your verdict?
Yes.
Juror in seat 13, is that and was that your verdict?
Yes.
Juror in seat 14, is that and was that your verdict?
Yes.
All right, ladies and gentlemen, on behalf of myself, my staff, and the attorneys, we sincerely thank you for your time and service. I know today's been a long day and it's been a long week, so we really thank you for your time and your commitment here. I always like to come back and say hello to my jurors. I know it's late in the day, so if you can't wait for me, that's okay, I understand. But if you can, I'd like to come back to say hello. Thank you.
All rise for the jury.
Okay, is bond denied here?
Yes, sir.
All right, bond will continue to be denied, and we'll come back here for sentencing on?
December 9th, 1 o'clock.
December, yes, does that work? December, yeah, go ahead.
My client has asked for a different sentencing date as the co-defendant, and I told him that I would ask the court.
December 9 at 1 o'clock.
Thank you.
All right, the motion is denied. Anything else for the record at this
Judge,
time?
again, there's a habitual that needs to be addressed at sentencing.
Okay, we will do that then. Ms. Lofton, anything else? Okay, all right.
All rise.
That was funny. She asked for her client, on behalf of her client, to have his sentencing different than co-defendant. She's like, yep, September 9th. It literally took her like 2 seconds. 2 seconds, not even 2 seconds, 1 second to make that decision. All right, so now we're going to do a press conference, and yes, both were found guilty as charged. Unlawful imprisonment ×2, first degree of Sam, and September 9th will be, let's see, September 9th is going to, let me get my audio up here. September 9th is going to be sentencing. So if they stream it, we will cover it. Now I want to do a press conference. We always look for press conferences, and they did. They had a press conference afterwards. So let's get to a presser here.
All right.
All right, I'm going to try closed captioning as well. Okay, here we go. Press conference of the family afterwards.
All right. Abdu, can you say and spell your name for us?
Sure. Abdu Murray, ABDU-MURRAY.
And who are you standing here with, Abdu?
I'm standing here with warrior princess, my mom, Linda Murray, with Mohib Murray, my brother, and Rahif Murray, my brother, and a host of our family and friends who love us dearly.
Abdu, tell us your thoughts on the verdicts.
This has been a horrific year, and this has been an especially trying week of that year, where we had to sit through a trial where my mom had to live through the horror of October 11th all over again. And we watched her do so bravely, and we all had to relive it ourselves. But we have a verdict that is just, and we are satisfied and happy with the verdict that is just, and justice was done here. We want to thank the Oakland County Sheriff's Department for the wonderful and professional work they've done in this case to bring it to this conclusion, to the Cato Parish law enforcement down in Louisiana for all of their efforts, and every law enforcement officer and agent in between. We want to thank Judge Polis for running an incredibly efficient, fair trial that reached this conclusion. We want to thank the jurors for their service in what was a very difficult week, I'm sure, for them as well. And we want to thank Jen and Emily and the folks at the Victim Services Unit and for all their care and attention to us in a very trying time. Our hearts are broken because no verdict of guilty can ever bring my dad back. But we will honor his life, his generous spirit, his strength of heart, and honor this woman with every breath we have.
What would you say to Zuazo and Hernandez if they're watching this from their jail cells?
I'm not ready to say what I need to say.
And can you tell us just something about your dad?
How does one sum up my father?
Larger than life.
Larger than life. Generous, strong, passionate, loved my mom fiercely, loved each one of us fiercely, and was a self-sacrificial man.
Yep. Just one thing I want to add to my brother, because I think accidentally omitted, thanking the Oakland County Prosecutor's Office.
Yes.
They did a tremendous job. We're very happy with what they did, their professionalism throughout, and we couldn't have asked for more, and we're just very satisfied with the verdict.
Does the
timing of this help, I guess, to try to take the next step? The day closer, so close.
That's a great question because
I suppose it does in a way.
it does, because in about a week or so, well, actually a little bit more than a week, it'll be the 1-year anniversary of my father's passing. And we'll gather together to memorialize my father for the 1 year. So yes, the timing is perhaps even providential, because it will help with healing. There's a hole we will never fill.
You never get over it, but you just learn to live with it.
Thank you, guys. We'll leave you alone. And just for the record, Mohib, Moheeb,
Yes.
Murray, and Rehif, Murray, Rahif Murray. All right. Thanks, guys. We'll leave you alone.
Thank you, thank you, thank you. Thanks, Todd. He's okay. Still a mom.
Okay.
Ready? Yeah, let's go. Let's go.
That was really sweet. That was really sweet. So I would expect their victim impact statements to be pretty sad, pretty powerful. So when that time comes, they're December 9th. We'll be here. December 9th, we will hopefully they'll stream it, and we will be watching it as well. So, all right, Psychosaurus Rex. Yeah, I'm glad. Wait, hold on. I'm glad Miss Murray had such a supportive and large size family surrounding her. Absolutely. Yes. Chris Mass says it's always the good ones that get taken. I know. It did, Queen Olive Ruth Ann. Yeah, it was a year ago. The 11th, 10th and 11th, So literally a year ago. So, Paula, it's mind-boggling that this went to trial so quickly when some trials linger in limbo for years. Yeah, it depends. It depends on circumstances and, evidence coming in and, tracking down witnesses. And they clearly they didn't need to do all of that, or they did it very quickly, I should say. I mean, of course, they have to track down witnesses and get evidence and all that, but they did it very quickly. Sally, he represented his family well. His dad is proud. I agree. Green-eyed cat, absolutely about Amanda. Doesn't know why she isn't an accessory, hoping her charges come now that these two were convicted. It's gotta be like right there. Because she didn't testify. It's not like she testified, got immunity or anything like that. I mean, she was absolutely a part of this. Northwest, wife Amanda needs bracelets. Yeah. Wasn't a complicated case, Northwest, to be fair. Yep. Yeah. No, yeah. You got the ring camera. You've got their DNA. You've got an eyewitness. I mean, you have his interrogation. Yeah, it's definitely. They put together it was well tried. Defense did what they had to do. They did what they had to do, and the state had overwhelming evidence. The witnesses came to them, right? Yeah, Paula. Lily Wayne, let's watch for Amanda's and Wendy's arrest. Yep, absolutely. So now, Joanne, if I don't know if you're going to watch this or not, but if you're listening, or tomorrow, we can tell Joanne, add to the 8-ball question, will Wendy be arrested today? We can now ask the 8-ball, will Amanda be arrested today? We did, Northwest. We got our 4 verdicts in 1 week. 4 verdicts in 1 week. That is absolutely a record. Just unbelievable. So, Widespread says, yep, definitely on arrest watch for Amanda. Yep. All right, so December 9th, we will put that in our calendar. December 9th will be their sentencing. And tomorrow, you know what? I wanted to take this moment and thank Mary Fitz for the Tiki Cat. I went to the post office yesterday, so we got Polly and all the kittens and all the cats got chicken and lamb from Mary Fitz. So I want to say thank you. And then Fur Baby's mom gave them seafood. So we got that. And then Psychosaurus Rex sent some food and some toys. Of course, they're loving all of the toys that have been sent. And then I don't think little Lulu is in our chat, so I'll say thank you for the window sling. Little Lulu sent us a kind of like the slings, the hammocks that we have here on the tables, but this goes on a window, I guess, or you could attach it to a wall, I guess, as well. But anyway, so I wanted to thank Mary Fitz and Fur Baby's mom and little Lulu and Psychosaurus Rex. So on behalf of all the cats in the house, thank you guys. And yes, well-fed kitties here. And I want to leave you with this. This is really this happened. I think this was Friday. So this was Friday. This is just too fun. You guys are just gonna laugh at this. Here, hold on. Here, check this out. Oh, meow, 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 meow. Hi, little Super Ball. Yes, tail in said face. All right, hold on. Sorry, this came in really big. All right, look at these two. Look at these two. All right, hold on. All right, look at these two. So, all right, look at those two little munchkins. I mean, that's just so. Hey! Stop it. So there's that, and then hold on. Then there's this. Look at that. I mean, come on. That's just adorable. So, very cute. Very cute. Yeah, they are twinning, yes. All right, so for Baby's mom, yes, thank you for the food, and little Lulu, Psychosaurus Rex, and Mary Fitz. So thank you guys, really appreciate that. The house of Kitty, thanks you guys. All right, so with that, thank you for joining us on a Sunday afternoon stream. Tomorrow, so we were going to do our deep dive on Bianca Ellis today, but then when I saw the verdict came through a clean stream, I'm like, ooh. Oh, and I called the news station, and they said they're still in jury selection. And so we're like, oh, let's save that for Monday. So that's why I wanted to clean up the verdict for Hernandez and Zuazo. So we cleaned that up. We got a clean verdict, got the press conference, so that was cool. And then now that frees us for Jose Soto Escalara. He has his sentencing tomorrow at 1:30. We'll be covering that. If it's streamed, hopefully it'll be streamed. And then we'll start our deep dive into Bianca. I keep wanting to say Bianca. Bianca Ellis out of Cleveland, my hometown. So this one hits close to home. And so we're going to start that. It's about a 3-hour stream with everything, with news and pretrial hearings and all that stuff. So that's going to be starting 9:30. So 9:30 to 12:30. That's Eastern. And then we'll break for our hour lunch. And then we'll do a new stream with Jose, and then if they do seat a jury, we'll pick up. I mean, because Jose probably will only be, it's a Spencer hearing, so the judge has to hear both sides to see, if in fact he is going to go with the jury recommendation of DP. So I don't know how long that will last. Maybe 2 hours, 3 hours. I'm not sure. But if Bianca's does seat the jury and then it starts, we'll be ready. We'll pick right up on that after Jose. So with that, you guys, thank you so much for watching. Thank you for spending your Sunday afternoon with us. And with that, thank you to our mods. Thank you to Erin for creating all kinds of cool graphics. And she's making couscous for me right now. So want to go help her with that. So thanks, guys. Have a enjoyable rest of your Sunday. We will see you tomorrow, Monday at 9:30 Eastern. And be sure that you take care of yourselves. Make sure you do something that do something good for yourself. Also, real quick, we're planning something for Halloween. We got some plans in for a Halloween stream, Halloween night stream. That's going to involve some fun characters, and we're going to be doing something fun for Halloween. So mark your calendars, Halloween night, maybe starting around 7:30 or 8 o'clock Eastern. We're going to do something fun on Halloween. So with that, have a good one. We'll see you tomorrow at 9:30. Bye.